Good evening, everyone. We'll make a start. I'm Chief Justice Helen Boskill, and I've got a very brief role this evening just to welcome you all to the Banco Court of the Supreme Court this evening for the W.A. Lee Equity Lecture. I wish to acknowledge our speaker, Justice David Burdisse, one of the Judges of Appeal of the Supreme Court of Queensland, the Chair of Queensland Gives, the Honourable Margaret McMurdo AC, and also to introduce this evening's major sponsor, Professor Rick Bigwood, the Academic Dean and Head of the T.C. Byrne School of Law at the University of Queensland. Would you please all welcome Professor Rick Bigwood.
Thanks for the applause, because I never get it at the end, so I guess that's timely. But thank you, Your Honour, for your kind introduction, and thank you for the use of this wonderful venue to hold this evening's lecture. May I also extend my own welcome to your honours, other distinguished guests and audience members to this, the 26th Annual W.A. Lee Equity Lecture for 2025, hosted by Queensland Gives and the UQ Law School. As with previous years, I acknowledge and thank the Honourable Margaret McMurdo, AC, Chair of the Queensland Community Foundation, for the opportunity to partner with the Foundation to present this event. Let me also begin by acknowledging, on behalf of the University of Queensland and Queensland Gives, the traditional owners and the custodianship of the land upon which we meet this evening. These are the people of the Yurruga and Turrbal nations of Meanjin, which we now call Brisbane. I pay my respects to their elders past and present, and extend the same respect to other Aboriginal Torres Strait Islander peoples present here this evening, or perhaps watching the recording from a different location later. I acknowledge the contemporary Queensland First Nations community who continue to maintain their identity, culture and Indigenous rights. We recognise their valuable contributions to Australian and global society. I'm not sure what the collective noun for an audience of equity nerds is, but whatever it is, welcome. This, as I say, is the W.A. Lee Equity Lecture, and each year it's held in honour of foremost equity and trust academic and author, Honorary Professor W.A. Tony Lee. This prestigious series of lectures continues a long tradition of maintaining contemporary debate on matters of equitable jurisdiction, technique, principle and doctrine, both in Australia and beyond. Tonight's lecture is titled Intestacy, Is It a Form of Estate Planning? And its presenter is doubtless someone who needs no introduction to the present audience, the Honourable Justice David Burdisse of the Supreme Court of Queensland. Justice Burdisse graduated from the University of Queensland in 1983 with a Bachelor of Laws Honours and was admitted as a barrister to the Supreme Court of Queensland in 1984. He was appointed Senior Counsel in 2001. His Honour has served in a number of significant roles, including as a member of the Queensland Anti-Discrimination Tribunal, Chair of the Queensland Nursing Tribunal and Director and then Chairperson of the Barristers Chambers Limited. He was also Junior Vice President and then Senior Vice President of the Medico-Legal Society of Queensland. His Honour has served as a member of the Continuing Professional Development Committee of the Bar Association of Queensland. Justice Burdisse has been the legal patron of Medico-Legal Society of Queensland since 2014 and was appointed Chair of the Supreme Court Library Committee in 2025. Justice Burdisse was appointed as a Judge of the Supreme Court of Queensland on the 2nd July 2010. He served as an additional Judge of the Mental Health Court from 2011 to 2014, and then as President of that court from 2014 to 2017. His Honour was appointed the Southern Region Judge of the Land Appeal Court in 2020, and in 2023, Justice Burdisse was appointed a Judge of the Queensland Court of Appeal. It is my pleasure now to invite Justice Burdisse to the lectern to deliver his lecture.
Thank you. Chief Justice, Justice Treston, colleagues, practitioners and friends, Thank you for doing me the honour of being here tonight to listen to this. I hope your expectations aren't great. Thank you, Professor Bigwood, for your very generous introduction. I am truly honoured to be asked to give the 2025 W.A. Lee Lecture. It is a prestigious lecture, and rightly so. And when you look at who has given it before, I am humbled to be asked to do so. Like most attendees tonight who are of a certain age, I was taught by Tony Lee at the University of Queensland. I was very fortunate to be the recipient of his animated and inspired wisdom. Tonight, I invite you to consider a question which in one sense is simple and in another sense is not, and that is intestacy. Is it a form of estate planning? It's probably not necessarily a form of estate planning that something like Queensland Gives would particularly like, but it arises in these circumstances. Ordinarily, when we think of estate planning, we picture intentional acts, signing a will, structuring a trust, making intentional choices. Intestacy, on the other hand, is the absence of that. It's either dying without a will or without a valid one, or ineffectually disposing of your estate. In Queensland, when a person dies intestate, the Succession Act prescribes who may administer the estate and who will inherit it. In that sense, intestacy could be said to be a plan, albeit a plan written by Parliament, not by the individual. The question posed tonight is, should a court recognise that people may reasonably choose not to make a will in reliance upon a distribution affected by the intestacy rules? Something of the history of intestacy. Intestacy as a concept is steeped in history with very significant religious overtones. These overtones seem to underlie a preconception in succession cases that intestacy is not a choice made by an individual. As far back as the Romans, the making of a will was considered important. From a historical point of view, intestacy was described in ancient Rome as a misfortune. There was a perceived strong duty of testation. In Roman law, succession was tied to the concept of familia. Succession was about continuity of the household and the survival of its social and religious obligations. The only function of a Roman will was to appoint an heir. However, early Roman law did provide for estate succession in the case of intestacy. The immediate heirs, that is, the children, were entitled to take an equal shares, and if the immediate heir predeceased the deceased, the children of the deceased's immediate heir took the share of the parent. Where there was no immediate heirs, the estate passed to those nearest who could trace a relationship to the deceased through the male line, and if they refused, the estate went to the nearest who could trace a relationship to the deceased through the bloodline. Ultimately, in the absence of kin, the estate passed to the state as a form of bona vacantia. Roman law thus created a model of intestacy that prioritised household preservation, reflecting a society that was organised around lineage and the perception of a perpetuation of family cults. Under Justinian, that system changed so that the general order of succession was children in equal shares, with their children taking the share of the deceased parent. If there were no children, parents of the deceased would take an equal shares. If there were no children or parents, siblings of full blood took an equal shares, with the share of a deceased sibling passing to their children. If there were no siblings of full blood or their descendants, siblings of half blood would take, and if there were no siblings at all, the nearest relatives took in equal shares. Ultimately, if there were no blood relatives, the estate passed to the deceased spouse. Succession laws in England developed from customs that originated in Anglo-Saxon times. One such custom was the notion that a deceased estate was divided into three parts: 1/3 to the spouse, 1/3 to children, and 1/3 for charitable purposes to benefit the soul. This last part was often referred to as the dead part. In the later medieval period, succession to property was shaped less by individual choice than by custom, feudal obligation, and ecclesiastical authority. The Church played a central role, not only in supervising wills, but also in receiving a share of the estate through the concept of the mortuary, effectively a death duty paid in goods or money. The Church likened dying intestate to dying unconfessed, and reasoned that such a person would be assisted in purgatory by a part of their personalty being donated to charity. In these times, a division arose between realty and personalty due to the rule that developed that the realty must pass to the eldest son. This rule meant that there was not a complete freedom of testamentary disposition. There was initially no recognition of a right of succession to the personal property of an intestate. The king, as parens patriae, seized and supervised an intestate's estate. The estate was used to defray the expenses of burial, to pay the debts of the deceased, and to meet the claims of the church, and then to support or advance a spouse and children, and if there were none of those living, blood relatives. Over time, the king's supervision of such estates became the responsibility of the ecclesiastical judge in the place where the death of the intestate occurred. By the 13th century, ecclesiastical courts assumed exclusive jurisdiction of chattels in a testamentary context. There were established procedures for administering estates, and probate was conducted to prove the testament by the executor named in a will. During this period, the Church declared that dying intestate was as culpable as dying unconfessed. This system was replaced after accusations that the clergy were confiscating the whole estate without distribution or making improper and inappropriate distributions. The Statute of Westminster in 1285 required that the intestate's estate be used to first pay the debts of the intestate, with the residue to be applied by the ecclesiastical judge, quote, as his conscience approved, end quote. The hardship that obviously could arise from such a discretion was not remedied until the Statute of Distributions in 1670-1671. That compelled the administrator of the estate of an intestate to distribute the personal estate of the intestate after the payment of funeral and administrative expenses and debts to the intestate's next of kin. A widow was entitled to 1/3 of the personal estate if there were children, with children being entitled to the remaining 2/3. If there were no children, the widow was entitled to 1/2, and the next of kin was entitled to the other half. If there was no widow or children, the next of kin received the estate, and if there was no next of kin, the Crown would receive the estate. In a discriminatory way, a widower was entitled to the whole estate. Next of kin was determined according to the civil law: parents, siblings, their children, uncles and aunts, and grandparents. Again, there was discrimination. A deceased mother did not inherit with the deceased father. The deceased mother was obliged to share with the deceased siblings. The model of succession that drew a distinction between realty and personalty dominated for centuries. It had harsh consequences. Widows were often left impoverished. The injustice of the system gave rise to a reform ultimately, with the Intestates Estates Act in 1890 in England marking a turning point. It introduced a statutory legacy for widows, recognising the need to protect the financial security of the surviving spouse. The real watershed came with the administration of Estates Act in 1925. It abolished the strict division between realty and personalty, eliminated the rule that realty went to the eldest son, and place the spouse at the centre of succession. Australia inherited that trajectory. Without a feudal structure or entrenched ecclesiastical jurisdiction, colonial law adopted the English rules with local conditions. By the 20th century, most jurisdictions, and eventually Queensland through the Succession Act, codified a system that closely mirrored those reforms. That pattern reveals that there was both a continuity and a change in relation to the way estates were dealt with, whether it was by will or through an intestacy. There was a continuity in the sense that intestacy has always sought to balance family claims through fixed rules, and change in the steady pivot from preserving property for bloodlines and the church to protecting widows and spouses, and now, through further reforms that are being contemplated, grappling with blended families, stepchildren, non-traditional households, and First Nations peoples' laws and customs. While some may argue that fixed intestacy rules produce injustice, two cases that the Supreme Court has heard in recent times evidence, in my view, the continued relevance of such rules in producing just outcomes. The first decision is a decision in the Public Trustee of Queensland as administrator of the estate of Hoskin, deceased, and Hoskin in 2016. That case involved the estate of one Phyllis Mary Hoskin, who died in 2009, aged in her 90s. She left no will and died without a spouse or issue. The central issue for the court to determine was the identity of her parents. Her death certificate recorded her father's surname as Hoskin and her mother's name as Mary. Phyllis's estate was valued at over $1.2 million, but it was largely derived from a bequest that she had received in 1938 under the will of Aaron Hoskin, and it had then been very wisely invested over the following decades. Aaron Hoskin was a wealthy and socially prominent pastoralist from Queensland's Darling Downs. His wife was Margaret. Together they had a number of children, all of whom had birth certificates, including one who had died shortly after birth. Phyllis Hoskin did not have a birth certificate. Various records suggested her date of birth could have been 1913, 1915 or 1916. Although Phyllis had been raised as a child by Aaron and Margaret Hoskins, had lived with them and their children through her to adulthood, and had been widely known socially as their daughter, and Aaron had referred to Phyllis as his daughter in his lifetime and in his will, specifically leaving a 20% share of his estate, quote, to my daughter Phyllis, end quote, Aaron's death certificate did not record Phyllis as one of his children. The confusion as to Phyllis's birth date arose because of conflicting records. School records recorded her admission to school on 23 July 1919 as being the age 6 years and 5 months, suggesting a birth date in early 1913. Army records recorded her birth date as 13 February 1913 and her next of kin as her mother, Margaret Hoskin. However, her death certificate recorded her age on death in 2009 as 93, suggesting a birth date in 1916. As Phyllis died without a will, the determination of the distribution of her estate hinged on the identity of her parents. The answer to that question determined whether her estate would pass to what were very distant relatives on either side, or to the Crown. Three possibilities were canvassed. First, that she was the natural child of Aaron and his wife Margaret, albeit one whose birth had never been registered. Second, that she was born to an unmarried woman, Joanna King, under the name Phyllis King, and later raised by the Hoskins. Third, that she had been adopted by the Hoskins in infancy, in circumstances so poorly documented that her biological parents could not be identified. This third possibility highlighted the challenges posed by early 20th century family practices. Before modern adoption legislation, arrangements were often private and informal. The Infant Life Protection Act of 1905 provided for oversight of, quote, nursing homes, end quote, for infants, but said nothing about succession. A child raised as part of a family could live their life in every social sense as a son or daughter, but with no legitimate legal recognition of that status. And so when intestacy struck a century later, the court was left with gaps with no statutory formula to fill it. The Hoskin case illustrated this vividly. Phyllis had been treated publicly as a Hoskin child. She grew up in their household, attended school under the name, and, as I said, was described as Aaron's daughter in his will. Yet family correspondence suggested otherwise. The official records were silent, and many years after Aaron's death, documentation from Aaron's son stated that Phyllis had been adopted by his parents and was not a natural child of his parents. After considering these contradictions, the court concluded that Phyllis was more probably the natural child of Aaron, but not of Margaret. A telling factor was that upon Aaron's death, despite Phyllis having lived all of her life in the house, Phyllis left the family home. Aaron, it would seem, suspected such an outcome. In his will, he left 20% of his estate to Phyllis, 5% to a son, and the remaining 75% to his sister. The will declared that he made no provision under his will for his wife and other children, other than those mentioned, for the reason that he had previously made adequate provision for them, and further that in making provision for his sister, he did so in the belief that on her death she would make provision for his children out of the estate. The conclusion that Phyllis was the natural child of Aaron led to her estate being distributed to the Hoskin descendants, as under the intestacy rules they were closer next of kin. Although not a factor in the decision, the outcome was probably the fairest, as the money had come entirely from the Hoskin family, not the family of Phyllis's likely mother. That family would have inherited if Aaron had not been Phyllis's father. Another recent and practical demonstration of the relevance of the intestacy rules is found in Public Trustee of Queensland and Ferris. There, the court was tasked with determining who should inherit the estate of a man with no spouse, no children, and whose only sibling had been adopted overseas more than 70 years earlier. The deceased was born in Slovenia in 1923 and died in Queensland in 2013. His birth certificate recorded him as an illegitimate child with no father named. His mother later had another illegitimate child, Adolf, who was adopted by a family overseas. The public trustee as administrator applied under Section 6 of the Succession Act for a Benjamin order, essentially a court order allowing for the distribution of an estate when certain beneficiaries cannot be found or verified. The court determined that the intestacy rules operated to entitle the sibling, albeit adopted by others, to the estate as the deceased's closest next of kin. That conclusion followed from the fact that the adoption laws of the overseas country did not operate as ours do, such that the sibling remained a sibling for the purposes of the intestacy distribution. The significance of these cases lies beyond the outcomes. They demonstrate how intestacy can provide just outcomes, albeit with a fixed statutory framework. Intestacy laws do more than distribute property. They embody in a legal form society's working definition of family. In the early 20th century, that meant grappling with the stigma of illegitimacy and of informal adoption. In the 21st century, it means it will have to confront blended households, step relationships, same-sex parenting, and technological innovations in reproduction. These cases, whilst rooted in the circumstances of the early 20th century, prompted me to reflect on a broader question. If the rules of intestacy can fairly accommodate the realities of what was then the stigma of illegitimacy, can they be a legitimate tool of choice by an individual when confronted with the challenges of a changing society? The question arises in the context of the practical reality that despite education as to the importance of an individual making a will, a significant proportion of adult individuals failed to do so. A 2015 joint research project between 3 universities and several public trustee organisations throughout Australia found that around 40% of adult Australians did not have a will. Whilst half of that number planned to make a will and may be said to be in the procrastinator class, the balance did not, with cost or difficulties in the process of making a will not being an explanation. The project was unable to discern the reason for deliberate non-will making, but I wonder if changing social times make the decision so much harder, leaving intestacy as a viable solution. So to return to the question, intestacy, is it a form of estate planning? Consider this example. A person who has children from an earlier relationship remarries. The new partner is unlikely to provide for the children of the earlier relationship upon death. A legitimate form of estate planning for that person who wants to provide for the children but who does not wish to create an argument in their lifetime by making a will which does not leave everything to their new partner, is to make a conscious decision not to make a will, knowing that the intestacy rule will provide a means by which a part of the estate is left to the children. Consider another example. A child receives a large multi-million-dollar settlement as a consequence of proceedings brought for damages for personal injuries, which has resulted in intellectual impairment, depriving the child of testamentary capacity. In an application for a statutory will, is it a legitimate consideration that the child would reasonably want to provide for both now divorced parents, but not wish to have an argument with the parent who has had the sole caring responsibility, by making a will that provides for both parents? Should a court, when determining whether this is a will that the child may make, if the child had testamentary capacity, consider it legitimate that the child may have determined to make no will, in reliance upon the intestacy rules which would provide for both parents? Finally, in the case of an application for a statutory will in respect of a person who has lost testamentary capacity by reason of dementia, is it a relevant consideration that that person has not made a will in their lifetime? Is it a relevant explanation for that fact that the person chose to rely upon the rules of intestacy to distribute their estate in a manner they considered fair, rather than cause an argument with their nearest and dearest as to what some might consider to be a more just distribution of the estate in their favour? There is authority in New South Wales, which has been followed in Queensland, suggesting that in the case of an adult who has lost capacity, evidence that the adult had the opportunity to make a will when they had capacity but did not do so would be relevant to the determination of whether an application for a statutory will ought to be granted. In those cases, it was accepted that in lost capacity cases concerning adults, the court should not presume the proposed testator did not wish to die intestate. However, those authorities concern individuals who had capacity but no longer have testamentary capacity. In those cases, there will generally be some evidence from which an intent to make a will or not to make a will may be drawn. My question raises whether a court should, in the case of individuals who never had testamentary capacity, start the inquiry when considering an application for a statutory will from the premise that both the making and non-making of a will are legitimate forms of estate planning. Doing so would allow the availability of distribution through the intestacy rules to assume a central role in the court's determination of whether the proposed will may be one the proposed testator would have made if they had capacity. Research undertaken by my talented and industrious associates suggests that this question has not been the subject of consideration by an Australian court in the context of applications for the making of a statutory will, so perhaps we should stay tuned. Now, I should have as a caveat, as I said, this is perhaps not the topic for a charity, when clearly it is important that people should make wills, because it isn't just family that they must consider, it is also the wider community benefit. Thank you.
Thank you so much, David. Did you want questions or not?
Yeah.
Justice Bodice has told me that he'd take questions if there are any. Are there any questions?
Oh, good.
Going once, going twice. Look, thank you so much, Justice Bodice. There is a question, okay.
Justice Bodice, sometimes, someone dies and a person might be identified as a child through tradition or the circumstances that you alluded in that case. What are your thoughts on that as far as lawmaking is concerned?
I think it is really important that I think it is important that when you're talking about individuals, like, for example, Phyllis, that they have the opportunity to be identified for who they were, including where they came from. So I do see it as an important role. It obviously was being decided in the context of one side or the other side getting the benefit of what was a rather large estate in the circumstances. But it has a benefit in respect of it. One of the challenges that I think we face is with the laws keeping up with our changing society, and the way families have changed and the way people identify as being part of a family is significantly different to what our laws would necessarily say is that formal status. And that, I think, could produce unfairness if we don't make sure that the law keeps up with it.
Any other questions? Yes, you've just really started something now.
Thanks for the presentation. So you spoke about the various social and political iterations of intestacy laws over epochs. As we look ahead to the future and the changing society as we see it relative to our neighbours across the border, where do you see intestacy laws going in Queensland?
I suspect they will always have to have a structure about them because they have to produce a result that can apply across the board. So the real issue is going to be things like First Nations laws and customs, being able to introduce those, and in a way also being able to adopt a form of family which isn't necessarily the legal structure of family as we know it, because that's not how people do things nowadays. But we still have to have, at the end of the day, some way in which you can identify that they in truth fall within that category that justly should benefit from the estate.
Judge, just on the point about the Indigenous culture and would you see there any utility in having a bench comprised of perhaps elders or people from that culture in the same way that perhaps the mental health court is, or in the magistrates court they have the Murray court?
I think the difficulty that it's confusing advice about understanding evidence and evidence. I mean, you would expect in those circumstances there would be expert evidence about what the culture, traditions or laws are. And I don't think a judge needs, therefore, somebody to assist them how to understand that. You would expect that to be the subject of evidence that is properly to be the subject of cross-examination. The difference, I think, is, for example, in the mental health court, one of the things is it's the assistance of understanding what is often a very complex question, not necessarily just in a legal context.
Justice, what about the situation of a de facto relationship, particularly where
those relationships can be quite fluid towards the end of someone's life. How is that potentially dealt with this concept that intestacy is an estate manageable?
Well, in a sense, it is now because of the way things are defined, but you have to have a point at which fairness would say that you must be together for a period of time, which would mean you are recognised as being truly in a relationship. And so that's, I mean, for young people, a week is a long time, but I don't think the law would necessarily see it that way. So I think the law presently does accommodate it. What the law probably doesn't necessarily accommodate is that families, for example, can often have more than two parents. There's a whole variety of things that can make a difference, and we've seen in the media in recent times exactly that, of an issue with a school in relation to who is the parent who can go to the parent-child end-of-year celebration.
Well, thank you. I think that was an indication, Justice Bodies, of how much interest there was in your very thoughtful paper. A consideration of the radical notion of whether intestacy is a form of estate planning. Turning that into a stimulating presentation takes a great deal of thought and effort and talent and a lot of time, a scarce commodity for a judge of a busy intermediate appellate court. I reckon the story of Phyllis and her dad Aaron could be turned into a pretty gripping Netflix series. Thank you for your thought, time and effort, and for generously sharing your wisdom and insights with us this evening. Thanks also to you, Chief Justice Boskill, for your continued support of this lecture series, for permitting it to be held in this magnificent space, for so graciously hosting us this evening, and for your and for all those things. There'd be no W.A. Lee Equity Lecture without Professor Tony Lee, now in his 96th year and sadly unable to be with us. I know he still follows this event with enormous interest. He suggested Justice Bodice as our speaker tonight and was thrilled that he was able to deliver this year's lecture. I thank Professor Lee for all he has done in the Legal Academy in Queensland and far beyond. My next thank you is to our presenting partner, the T.C. Byrne School of Law, University of Queensland, represented this evening so ably by the Dean of Law, Professor Rick Bigwood, and to our networking drink sponsors. You've seen on the screen Estate First Lawyers, Mitchell Solicitors, and De Groot's Wills and Estate Lawyers. Thank you all, of course, for supporting this important lecture series, always a highlight in Brisbane's legal calendar, as it was again tonight. Queensland Community Foundation is the inaugural sponsor of this annual lecture series. QCF, under the stewardship of the Queensland Public Trustee, and I acknowledge the Public Trustee Sunny Jouand, who is here this evening, is the state's largest public charitable trust. And as you've heard, I have the privilege of chairing its advisory board of governors. From start-up funds of $300,000 in 1997 under the leadership of then Premier, the Honourable Mike Ahern AO, QCF's fund body corpus has grown in just 28 years to around $168 million, thanks to donations in wills from those who wish to provide an everlasting intergenerational gift to Queenslanders. So yes, Justice Bodice, we don't like the sound of intestacy these days, but I didn't mind it so much when a third went to charities. Those were the days. QCF has distributed since inception a wonderful $57 million to Queensland charities, and that's just so far. It'll keep on doing that forever. QCF is also supported by living philanthropists who wish to encourage giving in their families or businesses. QCF now has over 250 sub-funds, supporting over 300 different Queensland charities today and forever. Thanks to generous sponsorship, every cent of every tax-deductible dollar donated to a QCF sub-fund goes straight into the fund without administration fees, and it's wisely invested by founding sponsor QIC, providing annual distributions to Queensland charities, as I've said, forever. We have sub-funds for specific charities or types of charities, or sub-funds where living donors decide which charity to support each year. We have a general fund to give support where it's most needed each year, and regional funds promoting a give where you live philosophy. In the coming year, QCF will provide a record $7.2 million to help charities all over the state, from Currumbin to Cunnamulla to the Cape and everywhere in between. It's fitting that QCF has initiated this annual equity lecture. The concept of equity in its broadest sense encompasses a notion of social inclusion and fairness. QCF is committed to a socially inclusive Queensland, distributing wealth from generation to generation on a needs basis, today, tomorrow and forever. Many of you will remember Rod Welford, former Attorney General and Minister for Justice from 2005 to 2009, who died recently. I acknowledge his erstwhile colleague, Grace, who's here today, and I think another former Attorney General, Linda Lavarch, is here also. QCF was within Rod's portfolio as Attorney General, and he was a fan. Now, Rod died earlier this year at only 67. In the final weeks of his life, with the support of his partner of 37 years, Gail Morton, and his disabled daughter, Lisa, he established a $1 million tax-deductible sub-fund through a living bequest to QCF, the Welford Sustainable Future Fund. But that wasn't all. Rod also made a multi-million-dollar bequest to QCF in his will. In combination with his living bequest, this will make Rod's gift of around $5 million the largest ever individual donation to QCF. Rod's gift recognises the opportunities arising from the demise of baby boomers like me, and with it, the largest ever intergenerational transfer of wealth. I know the succession lawyers here this evening are well aware of this phenomenon and the important role they can have in guiding it. So I'm all for making wills, Justice Bodice. None of this intestacy these days. Rod has ensured his vision for and service to the people of Queensland will continue long after we, our children and our grandchildren have gone. Truly a gift that keeps on giving, not as an individual monument, but as an enduring gift to others and to our community. What a legacy. Thank you all for coming this evening and for supporting this event. In a moment, we can mingle over drinks and nibbles outside, maybe buy some raffle tickets and chat to Tara, Kathy, Louis and Shauna from QCF's partner, Queensland Gives. They can answer all your questions. But first, I want to finish with some words from the late Rod Welford. He said, "I've had a wonderful life. I've had my own businesses, I've led national recycling organisations, I've worked as a minister in government and as a state education officer of Surf Lifesaving. I've travelled all over the world, both for leisure and work, and I've passionately pursued my primary interests, the environment, social justice and law, and education. It's the energy and personal resources you commit to people and the world that will always provide you with more satisfaction than just providing for yourself. QCF have the lowest costs of any similar organisation, and they offer complete flexibility. You can set up a named fund under their umbrella without the red tape. That matters, that enables impact." And his advice to our young people: get involved, make life about more than yourself. If you live to serve others, you will never be disappointed. Thank you all.